And now to judicial matters, where the Chief Justice of Nigeria, Justice Kudirat Kekere-Ekun, has expressed concern over judges delaying the delivery of verdicts in cases before them. The CJN warned that Nigerians could lose confidence in judiciary if judges continue to fail in delivering judgments within the expected time frame. Kekere-Ekun raised concerns about the low rates of case resolution among judges. She also criticized judges who failed to deliver a single judgment in a quarter, describing this trend as unacceptable. And to unpack this, we're joined by Executive Director, Sterling Center for Law, and that's Deji Ajare. Good evening. Glad to have you join me on the news.
Good evening. Thanks for having me.
All right. Like they say, justice delayed is justice denied, and the CJN has expressed concern over judges delaying the delivery of verdicts in cases before them. What do you make of that?
Yeah, just like you have said first, justice delayed is definitely justice denied. And I can say this to you as a legal practitioner who has seen how the impact of delays in the dispensation of cases it has on litigants. A lot of times, whatever they get at the end of that long drawn battle is usually so inconsequential most times that they don't actually feel that they have actually been able to get justice. And this is a dangerous trend because it tends to impact on the confidence that people have on the judicial system to serve justice. And this, if it is not checked, can lead to a situation where people will start taking the laws into their hands and resorting to self-help. And that is the reason you have a lot of cases of what we call jungle justice around the country. So it is important that this very critical and crucial issue is addressed as the CJN has already started.
Well, what would be your response to those who say that they need more time for cross-examination in court, whereby they need to investigate much more cases brought before the judge? How do you think they can implement efficient systems to make such cases resolved as soon as possible?
Okay. Now, I would like to speak practically on this issue. First, let me tell you that quite a lot of judges are they are really not in control of their courts. And that is so they allow lawyers, they tend to leave the doors open for lawyers and litigants to drag cases on and on. And that has become like the stock in trade of some lawyers, really, to just keep dragging cases, particularly when they are not very convinced that they have a case. So it is important that judges must be in control of their courts. There are cases where you go to court, cases listed, and the case file is not available. So, I mean, it's simply, for me, the way I see it is that judge is probably condoning incompetency amongst his officers. So, but most importantly, the steps that have been taken towards accountability for erring judges is very, very good. It is very important. I read, the warning that was, issued by the committee to the judges, and I think it's good, but it is not enough to just warn them. Mechanisms must be put in place for holding erring judges or non-performing judges accountable. And it is only when this happens that it can serve as deterrent to others and make all the judges sit up. This again will lead us to another issue, which is the issue of the age and health of judicial officers. There is a trend generally in the past 2 or 3 decades in Nigeria, where most of those people who make it to the apex court are those who are really at the end of their career, most of the time aged, old, and of course declining health. Now, this is something that we must start considering in elevation or appointment of senior judicial officers. A robust judiciary requires judges who are in good health, good physically and mentally, to handle the demanding nature of the job.
Well, I'm not holding briefs, for the judges, but then do you think or believe there are cases whereby, a file or a case indeed need be prolonged for genuine interrogation or investigation? Do you think we have such cases or scenarios?
You see, the thing is that a lot of the issues that appear to lead to, that to lead to the elongation of these cases are things that can be taken care of, attitudinal stance in place. That is one. Two, of course, just like the CJN has already also said, by adoption of the appropriate technology in judicial intervention. A lot of these things are already there. Some courts have already adopted them. I'm surprised really that the CJN is advising the judges of the Supreme Court to adopt digital tools and IT, because that is something that, I mean, the CJN should be providing for the judges ordinarily. A lot of these things will make these cases quite fast. And if you look at other jurisdictions, other places, you will find that, look, the use of this technology has made the judicial process very seamless, fast, and efficient. And most of the time, it even makes it less susceptible to manipulation. So I think, yeah, really, it goes without saying that we should by now be, 80% adopting the digital tools and digital case management systems, e-filing and virtual courtrooms. They should be things that we should already be doing.
All right. Well, if my memory serves me right, I know we have out-of-court settlements, but aside that, what other resolution mechanisms would you prefer be integrated into the judicial system for quick resolution of cases?
Thank you very much. I think that's another angle. There are quite a lot of cases that ordinarily should not even make it to the court, but they are there. And I think judges will do well in identifying some of these cases at a very early stage and referring them to the appropriate mechanisms for alternative dispute resolution, such as arbitration and others. And I think we're already in court.
All right, indeed. Thank you so much for your expertise on the news. Deji Ajare, Executive Director, Sterling Center for Law. Many thanks indeed.